Good afternoon. I'd like to call to order the Board of Adjustment meeting for September the 4th of 2014. Please silence your cell phones. Ask everybody to have a seat, please. Our first order of business is to receive the minutes of the August 7th meeting.
So moved.
I have a motion and a second. Register your vote. Minutes are approved. Do we have staff continuances?
We have one today. Item number 15, case number 13883 is requesting a continuance to October 2nd.
I would entertain a motion to approve item number 15 to October the 2nd.
So moved.
I have a motion and a second. Please register your vote. Continuance is approved. For those of you that may not be familiar with the board, a full board is 5 members. And today we only have 3 members present, and 1 member needs to leave at 3:30 today. So wherever we are on the agenda, this meeting will conclude at 3:30. If you want to request a continuance so that your variance request can be heard by a full board, because it takes 3 members to approve your variance request, we would entertain those. If you want to request a variance or a continuance to your variance request, if you would, just approach the microphone one at a time and we'll entertain your request.
My name is Larry Finn. I'm here on behalf of L.C. Edwards. I believe it's case number 13923. Request for a variance. We would ask for a continuance.
The next meeting date is September the 18th, or we have October the 2nd.
September 18th, just as soon as possible.
Before we vote, we will hear your protest. Okay. Which date did you request?
September 18th.
Okay. We'll allow Mr. Box to protest your request for a continuance.
Okay.
David Box, 522 Colcord Drive. We are here in opposition to the variance request, and we are also opposed to any continuance request. We had initially asked for continuance late last week, and were denied that request by the applicant, which forced myself and my client to expend a significant amount of time, effort, resources, and money to get ready for this hearing. In addition, I believe there are a lot of neighbors that are also here in opposition. We think it's only fair that this case be heard today.
If I may address that, we did receive a phone call from Mr. Box, but we're not even for sure which landowner he represents or who he does represent in this matter. So I think in order for us to hear his protest, it would be appropriate to determine whether or not the person asking or objecting to the continuance has standing to do so.
I have a question. I have 2 questions. So what you're saying, Mr. Box, is tell me who you represent first.
I represent Ballon Corporation. They own property immediately north of this. They have a significant amount of property and a significant investment in this area.
And second of all, you asked for a continuance by opposing counsel last week and were denied that request. Is that what it is?
Correct.
So you have gone above and beyond, I'm sure, over the weekend to prepare for this.
That is correct.
Okay. I'm almost inclined to hear it. I'd like to make a motion to deny the request to be continued.
We have a motion and a second. Register your vote. Your continuous request is denied, sir.
Thank you.
Hello?
My name is Stephen Hopper, 501 Northwest 41st Street, case number 13915 for variance. I'm requesting postponement. I was here last month and we ran out of time, and
Correct.
Looks like we're going to do that again.
September the 18th?
That'd be great.
Okay. I have a request from the applicant to postpone case number 16th to September the 18th.
Anyone in opposition? I'll motion for approval.
Thank you.
We have a motion and a second. Register your vote. Your continuance request is approved.
My name is Dan Laurent. I'm with Superior Neon Company, 2515 North Oklahoma. We'd like to request a continuance to September 18th.
Can you tell us what your case number is?
13922.
Superior Neon Signs. September the 18th or October the 2nd? September the 18th?
September 18th, sir.
Okay. Have a request from the applicant on case number 13922 for continuance to September the 18th.
Anyone in opposition? I'll make a motion for the continuance.
We have a motion and a second. Register your votes. Your continuance request is approved. Any other continuance requests from the public? If not, we'll proceed with the first case.
Item number 1, case number 13911, request of Derek Carter for a variance to the required number of parking spaces located at 2215 Northwest 39th Street.
If you would, go ahead and distribute your materials and then take the mic and give us your...
Just give them to Kathy.
Okay. We are asking for a variance for our parking situation at 2211 Northwest 39th Street. As you can see, the picture of the exterior of the building, the style of the property and the area it was built keep the parking situation limited over there because it's the pull-in style stalls. This parking situation worked well for many years at this location. It was a showroom and a factory for plumbing fixtures. It thrived in this building for over 30 years with this style of parking. It's a nice building. It's a 1950s era front facade and interior. I've included a picture of the exterior and the proposed floor plan. We have completed a structural engineer's report. I feel like the building's in really good shape. We have completed a structural engineer's report. No structural issues exist, and our plans are to do a complete remodel of the building to create office and retail space at affordable lease rates. Office and retail will fit well in the area. It will create some diversity in the area. This building is surrounded by hotels, bars, a car wash, auto mechanics, warehouses, a church, and counseling centers. You can see the map. It also, is very close to I-44 and Penn, between May and Penn. It's near the bus lines, and it does have right in front of our building a bicycle lane. There is heavy foot traffic in the area. We have shared our parking lot for many years with the neighbor across the street, an establishment called The Boom. They are now willing to share their parking lot with us to accommodate our tenants. We are projecting our tenant hours of operation will be regular business hours, Monday through Friday, and the business across the street, their hours are primarily evening, weekends, and they have over 40 spots to share with us. There's also a diagram of the parking that shows our parking lot and their parking lot. It's not a lot of traffic on the 39th Street. It's the part that's between May and Penn, so it's kind of a low traffic area. Our improvements to the building will help revitalize the area. Right now it is a dilapidated building that we are spending a lot of money on. It's located within the urban core of Oklahoma City. The building has been vacant for 5+ years, and this remodel will attract new tenants and businesses to the area.
Are you actually expanding the square footage of the property?
No, ma'am.
No, it'll be the same.
Same, yes, ma'am.
Is there anybody here to speak on this today? Anybody? I remember that you had come to us before about
Yes,
your
ma'am.
parking, your driveway width, and that there were some issues with that.
Yeah.
It seems to me like this is a good solution to your problem. I think, the historic nature of the uses in this area, it is an area that's undergoing some revitalization with some help from the city. It is intended to become a much more walkable area, and therefore, hopefully, the need for additional parking would be reduced. And I think it is unique in that sense. If there's not anybody here who wishes to speak on the matter, I'm going to move for approval.
I'll second that.
I have a motion and a second to approve the variance request. Cast your vote. You are approved.
Thank you. Thank you.
Item number 2, case number 13918, request of Helmerlich and Payne for a variance to the hard surface paving requirement and the maximum driveway width located at 5409 and 5413 South Hattie Avenue.
Please state your name and address for the record, please.
My name is Trace Strevey with Baird Hampton and Brown Engineers, 6300 Ridgely Place, Fort Worth, Texas, 76116. I will try to make this short. I know we're under a time crunch today. The staff report does a very good job of outlining the request that we're making. The campus, we're adding 2 new buildings to the campus, a new warehouse building that you can see, and then an office building. The trucks primarily use the southern driveway. Actually, this is the only driveway that they use. It is an existing 36-foot wide driveway. When we brought the plans to the city, we had to show that we were reconstructing it as a 30-foot wide driveway and go through this process. We're just asking to reuse it in its current size. That exhibit right there outlines multiple other driveways in this industrial zoning district that also have driveways that exceed 30 feet wide. You just can't take a big truck out of that driveway in a 30-foot wide driveway. The other variance that we're requesting is we have a small part on the back of the warehouse building where we have a loading dock that we would like to pave with granite paving in lieu of the concrete, because they utilize a large pad in the back for welding operations. It's a concrete pad that's laced with metal so they can hook up the negative electrodes and just weld on it. And we don't want to hard connect concrete paving to that welding pad and disrupt those operations. There won't be a dust problem. It's way in the back, and we're already hard surfacing all of the other parking and maneuvering areas required by the project.
Are you talking about crushed granite?
It's a crushed angular granite. It's not a flex base. It's a dust-free surface is what we're proposing. So I'll answer questions if you have any.
I'm comfortable with a motion for approval.
I have a motion and a second. Cast your votes, please. You are approved.
Thank you.
Item number 4, case number 13923, request of Elsie Edwards for a variance to the requirement that no adult entertainment use shall be allowed to locate within 500 feet of any area zoned for residential use located at 3605 South I-35 Service Road.
Before we proceed, I want to set some parameters for our discussion regarding this case today. The board will not consider constitutional challenges to the ordinance on adult entertainment use. Constitutional arguments shall be reserved for the court. The board is not here to decide whether adult entertainment uses are offensive or immoral and should not be allowed at all. Objections from competitors are not relevant.
Thank you.
Please, your address and name for the record, please.
May it please the board, my name is Larry Finn. I'm here on behalf of the applicant Elsie Edwards. I'm with the law firm Rubenstein & Pitts at 1503 East 19th Street in Edmond, Oklahoma, 73013. As set forth in our application, we are asking for a variance for relief from Chapter 59, Section 9350.4, Part B, Part 3 of the City Code regarding the distance requirement of adult entertainment use from residential areas. Now, I reviewed the staff report. It looked accurate. I didn't have any complaints regarding that. And so, if I could, I'd like to kind of just talk about the variance that we're asking for. Where this property is located is 3605 South I-35. As indicated in the staff report, the area around the property is predominantly zoned heavy industrial and also some commercial, including our particular piece of property. Now, in order for a variance to be granted, the board must consider the 4 criteria set forth in the statute, and I won't belabor that point, but I'd just like to say that based on the evidence that those criteria are met and that we should be approved for the variance. Now, historically, this property has been used as a business and is operated as a bar, a dance club, a nightclub, and also for adult entertainment uses. Back in 1983, the previous landowner was Parkey Inc., and they applied for this very exact same variance for adult entertainment use within 500 feet of a residence. that variance was initially denied, and upon appeal to the Board of Adjustment, it was approved. Now, there's been some confusion as to that sequence of events, and my understanding is because the land card, the tract index card that indicated that this variance was actually granted, was placed on the neighboring property. So, just going through the standards of 11 OS 44107 and the relevant city code, the first part is that the application of the ordinance to the particular piece of property would create an unnecessary hardship or result in exceptional practical difficulties. Now, as we set forth in our brief in support of the variance and our initial variance application, Red Light Nights, which is the business that currently operates at the location, is owned by Elsie Edwards. It's Red Light Nights Incorporated. Now, she is the sole owner, the sole 100% owner of the business, and this is her only business, her sole business. Now, looking at this standard for the application of the ordinance to the particular piece of property, as we've indicated, more so as far as it concerns Ms. Edwards, the applicant, she would probably very well go bankrupt herself if she did have to move her property. But looking more specifically at the particular piece of property and whether or not it would create a hardship on that, the property, the area, the building itself is a wide open space, similar to this room. There's no divided rooms except for the back, which is the receiving area for drop-offs and deliveries. And so if the property was not allowed to continue on with its present use and how it has been operating and it was operating, from what we can tell since 1983 when it was initially granted the variance, then based upon the particular piece of property, the building would either have to be redone, gutted, restructured. They would have to put in individual rooms to make it suitable for something other than adult entertainment use or bar, which would also require the granting of a variance, which we also currently and presently today have a variance allowing the sale of alcohol within 300 foot of a residence for the ABC3 overlay district. So, in looking at the first criteria, the application of the ordinance to the particular piece of property, we already have a similar variance that allows for a special use within so many feet of a residential property. If the property was not allowed to continue with that use, then there would be a significant hardship on the property itself because the building itself would have to be redone. They would have to come in and gut the building and repurpose it for something else other than adult entertainment use or bar for which it already has a variance. Number two, such conditions are peculiar to the piece of property. Now, this was probably the trickiest factor for me in looking at it, but I believe that the evidence can overcome that. Now, this property Red Light Nights itself has used the property at its present location for over 6 years for this very exact use that it has been using. So, this particular use of the property is peculiar to the property. Now, in reviewing whether or not the pre-existing use of the property could be considered a peculiar condition, there is a case, it's a Walking Stick versus Board of Adjustment of the City of Tulsa, site 1985 OK70, that deals pretty much with a similar situation, where the Oklahoma Supreme Court held that the landowner's requested use of a property was not peculiar and did not allow the variance that it was granted. In that case, the board granted the variance that was requested by Amco Production Company to permit the drilling and operation of a test hole outside of a structure. Now, in that case, what they had to do, they were drilling a research and development oil and gas firm. They had to construct a building around the test site where they would drill a hole down into the ground. Now, what the applicant did in that case was ask for a variance so they could receive an exception from having to build the hole in an enclosed building for purposes of that they couldn't because it was a research and development firm, and they couldn't tell what effects the drilled hole would be, or what effects their technology would have if the hole was placed inside a building, which generally most oil and gas wells aren't placed inside of a building. And so they asked for a variance. Now, they tried to, the board granted the variance, and then on appeal by the landowners, arguing that the variance should not have been granted, the board argued to the Supreme Court that AMCO needs to test tools under simulated field conditions which cannot be accomplished within an enclosed building, constitutes a peculiar condition that would satisfy section, a similar section as we have right now. The Supreme Court did not find that argument availing, and what they looked at with that particular piece of property was that what the developer wanted to do, what the person wanting the variance wanted to do, was to use the property for something else other than what it was already being used for. So therefore, it couldn't be a condition that was peculiar to the property because they were seeking to make the property into something that it wasn't. They were wanting to conduct other types of uses on the property that they were not already using. Now, compare that case with our case where we've had a use, and we have been engaging in this use. We're not seeking to expand the use. We're not seeking to change the use. Back in 1983, a variance was granted, and all we are seeking is more or less to renew that very same variance to allow for this very exact same thing that has been historically done on the property. Number 3, relief if granted would not cause substantial detriment to the public good or impair the purposes and intent of the ordinance or comprehensive plan. What the court, or what this test focuses on, is whether or not the requested variance would be contrary to the public interest. Now, if we look at the surrounding area, it's zoned predominantly commercial in industry. It's right off of I-35, which is right off the I-35 corridor, which is generally not a residential area. The residential zones currently or the residential zones and use of the property have been in existence for a number of years. There's no pending request or any action to expand the residential use of the particular area, and especially within the 500 feet of the property. So looking at this, whether or not it would cause a substantial detriment to the public good, the property has been used for adult entertainment use in the past for a significant period of time, and there's no worry about our use impairing future development of the area or existing use of the area because of the historical use of the property. And finally, the variance, if granted, would be the minimum necessary to alleviate the unnecessary hardship, and substantial justice would be done by granting the variance. Red Light Nights has been at the location at issue here for the past 6 years. For the past approximate 30 years, the property has been used for some sort of use that requires a variance because of its location next to residential area, or to residential zones. Now, the residential zones have not expanded in that time. They've not changed in that time. The use of the property has not expanded in that time. The use of the property has not changed in that time. Quite honestly, what we're asking for here would be the minimum necessary to alleviate the unnecessary hardship. And if the hardship was granted, then we would be able to conduct our business as we have been in the past historically. And with that, I conclude my case.
I would invite any board members that have questions for the applicant before we excuse him and hear others.
I have a couple questions. First of all, you make an argument about the bankrupt and the economic situation, the economic impact this would have upon the applicant.
Yes.
Well, we're in a geographical location where we've had a adult entertainment club in 1983, was for 1 year, and since 2000 has been an ABC overlay. So for 14 years, until 6 years ago, for 8 out of the past 14 years, this has operated as a functional bar. Is that correct? Am I correct in that?
I believe so. It has operated as a bar, yes, historically in the past and consistently, so yes.
So if your client is denied the variance, they could retrofit it back to a bar, and theoretically, the ABC permit would still be in place, right? Is that correct? That's a question for staff, I guess. Okay.
And if I may address that, the way we look at it right now is that given the economy and the times and the location of the actual location, the physical location of the building, there's no near eating establishments, there's no near other conveniences that could be located next to other bars. There's no place where people would come from another area to come to the bar. For instance, if it was next to other commercial areas, if it was maybe not necessarily located in Bricktown, but maybe even down the road from a bowling alley, some other type of establishment where people could go to, and then they could eventually filter to the area. And if it was to be converted into strictly a place that served alcohol, it would lose any of its allure to people. We would lose a significant amount of our business because there's just no reason that people would want to drive all the way to 3605 South Haiti just to drink with there nothing in the area and there's no inlet or outlet for people to go to or come from.
Any other discussion before we?
Well, I think the point, I think that's perhaps more relevant to the question that you're asking is that the financial hardship that might or might not be caused by the denial of the variance is really not something for us to consider.
Agreed.
That's really just not part of our consideration. What I would like to confirm with you is that you are telling us that the property has been operating illegally as an adult entertainment use for the last 6 years.
I would not say that it's been operating illegally. What I would say is that we have been operating. I believe that there's been an issue with us not getting a permit, and so, but I don't think it would be fair to say that we've been operating illegally. We have
without a permit.
Well, and we've been operating without a permit to conduct this particular use on the property. Now we have permits to do a variety of other things, the ABC overlay district to serve alcohol, to do a number of other things on the property. So this specific use of the property, I think I would have to confine us to not having a permit only for the adult entertainment portion. And so,
Okay.
thank you.
I would like to excuse the applicant and allow the others that are here to protest your variance request speak. If you would, have a seat.
Thank you.
Mr. Box?
Mr. Chairman, members of the board, David Box, 522 Colcord Drive. I am here on behalf of Ballon Corporation in opposition to the variance. For purposes of the record, staff is handing out a series of exhibits as well as a series of published opinions from both the Oklahoma Supreme Court and the Oklahoma Court of Civil Appeals. Just for identification purposes, exhibit number 1 is a news article from News OK. Exhibit number 2 is a series of responses from the Action Center regarding the subject property. Exhibit number 3 is going to be a aerial map of the subject property as well as the property immediately west that has a combination of 12 lots, 6 of which are used currently as single-family residential, and 6 lots that are zoned for single-family residential. Exhibit number 4 is a printout received from the Oklahoma City Police Department regarding various incidents from this location dating back to 2000, and since 2011, what the report shows is there have been a total of 48 cases on the subject property, 13 of which resulted in arrest. What I'm going to focus my presentation on, yes, ma'am.
Before you get started, are you on here somewhere, your client's property?
Yes, Cindy, if you could pull up the map. can you pull up the city's zoning, or did you show her? Okay. What I'm going to focus on is not only is our opposition to the crime element and the hindrance to the public good, but also the applicant has failed to meet the statutory conditions. As this board knows, you are in a position to evaluate variance cases based on the 4 conditions that are laid out in the statutes. The first of which is the application of the ordinance to the particular piece of property would create an unnecessary hardship. When we look at the case law, unnecessary hardship is an element that has been litigated for years. The applicant would have you believe that the financial burdens placed on the applicant by the ordinance creates an unnecessary hardship. In support of that, in the brief that you would receive in your staff report, they cite to the Red Dog Saloon case. And if we look at the Red Dog Saloon case at paragraph 11, it quotes, "Financial loss has little bearing on whether an unnecessary hardship has been established," end quote. There's been another claim that there's a significant monetary investment into this property because of some retrofitting that was done to allow the adult entertainment use. If we look at the Board of Adjustment of Oklahoma City versus Puckett, which is an Oklahoma Supreme Court case, you had a similar argument. There the argument was that hardship was because of the money invested in a driveway. There the court said, and I quote, "The so-called hardship is the consequence of his own acts rather than that of the ordinance provision," end quote. And that's exactly what we have here. If there's a hardship created by retrofitting the club, it's a hardship created by their own acts. Similar case, matter of Schrader, which is an Oklahoma Supreme Court case. There the hardship was claimed that they had spent a significant amount of money constructing a carport. And there the court said, generally, a hardship created by the owner of the premises constitutes no valid basis for a variance. So again, all the elements that they've claimed for a hardship have been financial. There's specific case law on point. We do not think they can meet the first element. As we go to the next element, where such conditions are peculiar to the piece of property involved. Well, here I would submit that there's nothing peculiar about this piece of property. There's nothing more peculiar about this piece of property than any other property along any highway in Oklahoma City that happens to have residential on one side and highway frontage on the other. The applicant would have you believe that because the use is in violation of the code and it's been going on in violation of the code, that somehow creates a peculiar situation. To follow that train of thought, all you'd have to do to get a variance is dodge enforcement for a number of years, come to the board and say, we've been doing it for so long, it really makes this property peculiar. That is simply not what that element means. Allowing a self-created hardship to justify a variance would essentially repeal the ordinance in itself. Third is the relief, if granted, would not cause substantial detriment to the public good or impair the purposes and intent of the ordinance and comprehensive plan. This is probably the one that when you look at this variance is most important. When we look at the public good, I think it's important that we look at some of these exhibits. Exhibit number 2 is a list that we received from the Action Center. And what you have is, since 2009, 53 separate complaints for this property. And of the 53 complaints, 16 of the complaints warranted a citation being issued. 14 of those, the complaint references no citation issued because of the pending lawsuit. I take that to mean, had there not been a pending lawsuit, they would have filed a citation. So 30 separate citations just in the last 5 years. Additionally, if we look at the News OK article, and I believe some of the neighbors are here to address some of the specifics in it, but what you see is the neighbors have bullets flying. One neighbor was quoted saying he can't keep gasoline in his cars or his equipment because the patrons siphon the gasoline from his equipment. You have drug use. You have one gentleman reporting that he saw a employee of the club engaging in sexual acts with a, I guess, patron of the club in the parking lot. There are 11 kids that live in this area. And if we look at what is going to be exhibit number 3, which is the area, and you see immediately west of the Red Light Nights building, you have 2 houses. But you have half the block zoned for residential. On the other side of the block, you've got 4 houses and 3 additional lots. You have a total of 12 lots zoned and/or used presently for single-family residential. The applicant stated that this was a heavy industrial area and a commercialized area. If you look at the block immediately surrounding the subject site, it's a residential area. Over half of the block is residential and used for residential. Additionally, if we look at Exhibit 4, as I referenced earlier, this is a report from the Oklahoma City Police Department. And as I referenced, since 2011, we have 48 separate incidences with 13 arrests. Since 2000, we have 117 incidents. There was some discussion about whether or not the applicant has been operating, I guess, in violation of the code or without a permit. And what happened was, in 1983, the board granted a variance. Subsequent to that, a person brought a case in district court seeking to overturn the Board of Adjustment's grant of the variance. The district court overruled the grant of the variance. In 1986, there's a journal entry of judgment in that court case overruling the granting of the variance. Therefore, since 1986, there has been no variance granted for adult entertainment use. So when we look at whether or not the variance will impair the purposes and intent of the ordinance, that is the only thing that granting the variance can do. The purpose of the variance is to limit this use within 500 feet of a residential zone. But not only do we have the zone, we actually have the use, which is a heightened requirement. So when we look at Banks v. City of Bethany, at paragraph 5, it says, the board may not, under the guise of a variance, nullify the zoning ordinance and derogate the fundamental character, intent, and true purpose of the zoning law. Well, that's the only thing this variance could do, is undermine the intent and purpose of the ordinance. Finally, the variance, if granted, would be the minimum necessary to alleviate any unnecessary hardship. I would submit to this board that the applicant hasn't met element 1, 2, or 3, so I don't even think we need to address 4. But if we do address 4, there are multiple other locations across this city where this use would fit into the code parameters. So this is clearly not the least necessary to alleviate a hardship. And as I said, if it is a hardship, it's self-created. And the courts simply do not allow a self-created hardship to get a variance. The applicant has not and cannot satisfy the statutory conditions. Therefore, we would ask that this board deny the variance with specific findings similar to those arguments raised in previous Supreme Court cases.
Questions from the board?
I don't have any questions at this time.
Thank you.
Thank you. Mr. Razor? If you would, sir, just give us your name and address for the record and speak into the microphone.
I'm having real trouble hearing in here. You want my name?
Your name and address, please.
My actual legal name is Kenneth Ray Racer, R-A-S-O-R. I go by Doc Racer. I'm an old Navy corpsman, the reason for that. Okay. I live at 3632 South Glen, which is across the block from Red Light Nights.
We are short on time. We have to adjourn this meeting in less than 30 minutes. So if you would, if you could, an hour and 30. Okay, I'm sorry.
Do what?
I apologize. Go ahead, sir. Go ahead and speak.
Okay. Well, just an old country boy, I've lived it. So he's giving you the legal stuff, and I'll tell you what I've seen, if you don't already know. For one thing, that map is not showing one major thing on there I see right off the bat. We've got a city park that goes from Prosper Park to the railroad tracks down by Cesar Chavez and the new school. Hundreds of people use it. School children use it for a racetrack, for a track. The teachers set them out. And they come back later in the evening when it's cool, on up till I've seen them out there at 11, 12 o'clock at night. We measured it a while ago. It's 63 feet from their property line to that parkway. That's the only place in that part of town, that people can do that kind of recreation. As far as the other part, I noticed in this thing here it's talking about, there's actually 6 residential houses in there. Mr. Box covered everything else except what we've seen. Many, many instances of things like dope transactions, sex, across the street from my house, right in front of our house, in the parking lot over at the shop. We've had to put in all kind of surveillance stuff, and still that don't catch it all. Gunshots, I've got one in my truck, two in my house. Neighbors on either side's got them in their house. I've got two over at the shop. One of them came in from above. That was over a 5th of, what is the Mexican holiday? The 5th of whatever. Anyway, we got that one. We got two that one holiday. One through the side of the building. We lined up the shots like they do with CSI. Went right straight over, right by their front door over there. So we know where all this is coming from. Now, up there on that corner lot where it says, I believe that says I-2 or I-3 or whatever it is, I moved there in 1969. Before that, I was up on 29th Street. So I know the history of that place, one side or the other. I know every property owner in that area on both sides of the highway, and I'm a nosy old man. If something's going on out there and it ain't right, I'll challenge them, because somebody's got to do it around there. We call the police and they do a great job, but they can't be everywhere all the time. And these people cause us lots of problems. I don't scare very easy, but it makes you apprehensive. It's right back here in the back of your head all the time.
I understand. Any questions or comments from the board members?
I have no comment.
Thank you.
Mr. Gilliland. Thank you. Mr. Edwards.
My name is Keith Edwards. I live at 909 Northeast 21st Street, Oklahoma City. I just want to object to the actions, as well as mention that there is a trail that goes through the area, located basically through the designated area of Red Light Nights, and that I am currently in district court, and the attorneys that have represented for the applicant have also represented in front of Judge Parrish that they're not doing adult entertainment. So we have a kind of a conflict of different stories being presented in the two different deals. We are set to be heard tomorrow on the same matter as well. So I just wanted to voice that as well. Thank you.
Nick, did you have a question?
Yeah, I have a couple things I'd like to. Sure. The matter for Judge Parrish, we're not going to get involved. We talked about that. I don't really have any. That was the only thing I want to say. As far as the exhibits presented by counsel at opposition, I don't know if we can take into account Exhibit 1 as that should be disregarded, right, Danny, since it's from the newspaper?
I think you put every credibility you wish to attribute to that.
Okay, well, from my perspective, I would not consider that into evidence, but based on Exhibits 3, 4, and 5 and the arguments presented, I would make a motion not based on any First Amendment, moral ground, or anything else other than the fact that we do have a very unique situation here where we have residential, industrial, kind of a mixed use, and there has been a significant interest in public safety. I would make a motion to deny the variance request.
Before we act on this motion, I would like to give the applicant the opportunity to rebut or respond to the objections that have been heard, sir, if you would like to. You may respond.
Before he does that, I have a few things that I would like to say that he might want to respond to, so I'll go ahead and say them. I am not persuaded by the arguments either in the brief that we were presented or by the arguments made here today that the current use of this property is its only viable use. As I stated earlier, I don't think that the financial hardship is really relevant to our considerations. I agree that they are self-created for what that's worth. But the idea that because this property has been used, I would say illegally, you would say without a permit, it does not provide any sort of precedent for its continued use in any way, shape, or form, as far as I'm concerned. It certainly doesn't constitute any kind of peculiarity of use for the property, which seemed to be the argument that you were making sort of backwardly by your reference to the case law. The idea that the operation of this property does not constitute any negative impact on the surrounding property owners without knowing anything until it was discussed just moments ago about the newspaper articles or anything else. To me, it is simply not tenable that a use like this is not a negative impact on a residential use. The very reason why it is dealt with specially under the municipal ordinances is because there is some need for separation of these kinds of uses from, for instance, residential use. And fourth, I guess I would just say the idea that the continued use of the property as a bar and or adult entertainment use somehow means that the grant of a variance is the minimum action that would be necessary to alleviate hardship, to me is just upside down. It's just backwards. So being completely unpersuaded by those arguments, and I must say as well, not by reference to the article, but by reference to the brief, unpersuaded by your client's so-called efforts to be a good neighbor, which I notice are conditioned upon the grant of the variance, to the extent that they are even commitments, that if they get the variance, they'll check into security. If they get the variance, they'll see whether access to the property can be taken from a different location. I'm simply not persuaded. I do not think that this is an appropriate location for this use. I don't believe that you've met the statutory requirements on any of the 4 points, and I simply can't support it.
I invite the applicant back to respond to the objections.
Thank you, Board Member Powers. And if I may, I would like to begin with addressing her points, and then I would like to address just very briefly the points raised by the individuals in protest. Currently, the current use of the property, as it stands now, does have an effect on whether or not the variance should be granted. For one thing, the variance, this very same variance was granted back in 1983. Now, there's been arguments made that there was never a condition, that there was never a permit applied for, that there was never any type of action taken by the owner of the property to use that variance. But I would say that we did not even know about this variance until just recently. I realize that there's been some issues with the 1983 variance, but as I addressed before, the reason that we could not find that particular index tract property card was because the property was labeled with the incorrect address and it was placed in the wrong spot. So going back to the first point here, we're trying to justify the variance by the current use of the property is not entirely all that we're wanting to do. And what we're wanting to do with the permit and with getting the variance right now as it stands is that the property has historically been used. And we're not seeking to further the use or engage in a use that was not granted before in the past. And I believe, I had it down here in my notes, I believe that was the first point here, and then I believe in conjunction with that there was some issue regarding the applicants, whether or not the impact this would have on the applicant had any bearing for the determination as to whether the variance should be issued. And what I would show the board is that whenever you look to see whether or not a variance should be granted, considering the elements, the variance if granted would be the minimum necessary to alleviate the unnecessary hardship. Now, the way that that provision has been interpreted is that right now there's a hardship on the property, and there's also a hardship on the applicant. If we look at the Red Dog case, they touched on this very exact same issue, where the applicant himself indicated that he would probably go bankrupt because of the financial investment he had on the property. Now, if you granted the property a variance, but there was nobody there to use the variance, what would it matter? whenever we look at the hardship that would be encountered if the variance is not granted, you must look, and this is why the case law looks at something more so than just the peculiar use of the property. And that's also why the peculiar use of the property is addressed at section number 2. So going back to the effect it would have on Ms. Edwards, I think that that is definitely relevant. Without the variance, this is a hardship that one of the parties that would be affected, this is what would happen to them. And I think that's very important based on the case law. Number 2, because the property is being used illegally, we cannot continue to use the property as such. Well, this is exactly what a variance, the purpose of a variance, is to allow for the use of the property in such a way that you could not originally do so without the variance. The way the zoning law works is that it regulates the use of the property. Now, if someone wants to use the property in a different way, in a way that's not allowed, then what they do is they come in and apply for a variance. Now, the case law holds that if you have somebody coming in wanting to buy a piece of property and then they want to set up this brand new business or brand new use that is nonconforming in an area that they cannot, then this way, that factor that they came to the property knowing that they couldn't use it weighs heavily against them. Now, in this particular case, even though the property has been used, as we stated, illegally or without a permit, that in and of itself is the purpose of the variance, is to allow for a use of a property that you cannot use otherwise. Number 3, it's not feasible as it is currently being used, if I have my notes down here correctly. And so what I believe Board Member Powers addressed with that particular issue was whether or not we could use the property in another way, for instance, as a bar, or for instance, as just something else other than adult entertainment use. And while that would be feasible, let me take that back, not necessarily feasible, that would be feasible in a perfect world, where somebody could take a piece of property, they could say, okay, you're using this property for A. Well, we don't want you to use it for A, we want you to use it for B. Well, in a perfect world, that would be possible. But given the facts of this case, how the property is isolated from other types of commercial districts, how the predominant use of the surrounding area is industrial, as indicated in the staff report, there's just no market. There's no one that would want to come to an industrial area to drink. The allure of the property is the use that we are requesting the variance for. And number 4, the minimum action necessary to alleviate. I would just like to clarify, I wrote that brief that we submitted, I believe it was on Friday, and I wrote the initial application as well. And the reason that language was included was because we've actually been in contact with companies to go about seeing what it would take to construct a fence. I met with Mr. Razor, myself, for several hours last week, and we addressed his concerns. And a lot of his concerns could be resolved as set forth in the brief. Number 1, he was worried about there not being a fence around the property. And it was a very valid concern, because what he would say was that people would drive up to the property, pull in, and then just pull out on the other side. Now, if we were to place a fence in that area around the building, we could keep that from happening. This would prevent traffic from flowing onto Haiti and causing the disturbance, nearly every single one of the disturbances that he's referring to, the loud noises, the trash being placed in his yard, the issues with, I believe that there was an issue with people wandering over. If we had a fence located around it, which we discussed with Mr. Razor, and we both agreed that was a good idea. And the reason that I said if we were granted the variance is because it would not make much sense for us to go about building a fence right now if our use was not allowed, if we were not granted the variance and just having thrown all that money away at the fence. And now that language is not conditional on anything except for whether or not we get the variance. If we were to get the variance, then yes, we agree, the landowner agrees, the landowner agrees that we would take all reasonable steps, which includes putting in the fence, which includes hiring a private security guard, which would probably address the other half of Mr. Razor's concerns. regarding the use of the property. And now, if I may just briefly touch upon the arguments made by Mr. Box, and specifically the exhibits. Now, I have a huge problem with these service requests, these Action Center service requests. For number one, if you look at the very first page of the service request here, what is the service that is being requested? What does this piece of paper tell me? It tells me there's a service address at the property address, the location's blank, the service code is AET, and next to that is adult entertainment. Action Center contact, Chris Moses. Customer contact requested, blank. Service response, citation issued. Citation issued for what? Who made this report? Who made this request? What does this piece of paper tell me? They're telling me that it's someone calling in and reporting complaints regarding the use of the property. Where's the complaint regarding the use of the property? It's adult entertainment. Maybe that's what it is. But did the customer ask for something to be done? Now, I'm not saying that we can completely discredit that no one's ever complained about the property. I would be hard-pressed to say that with a straight face, but what I am saying is that you can't just say, look at this stack of papers. This is terrible what's going on here. Whenever these pieces of paper, I could basically just tell you, well, this is the good stuff going on here, and it would mean nearly almost the same amount. There's just no identifying information as to what the Action Center service requests actually mean. The next page, the same exact thing. The next page, girls doing table dancing with no tops is illegal for adult entertainment or exotic dancing to occur without proper zoning. That's why we're needing the variance. I just don't think it's very fair, and I don't think it's very appropriate for people to come in with documents that maybe they created, maybe these are calls that they made, maybe it's not. We don't know what these are. They did not tell us what these are, except what they say on the front of on the piece of paper there. There's no indication as to whether or not those are actual complaints, or as to whether or not they have any bearing on the issues to be decided before the board today. And so just to recap very briefly, the application of the ordinance to a particular piece of property would create an unnecessary hardship or result in exceptional practical difficulties. Now, the use of the property, the way the building is constructed, is for the use that that a variance was initially granted for back in 1983. That's number one. Number two, such conditions are peculiar to the particular piece of property involved. This particular piece of property, it has so many peculiar conditions to it. Since in 1983, it was granted a variance. Right now, from what we can understand, that variance is expired by its own terms because someone didn't apply for a permit. But we don't know if someone applied for a permit or not. We just don't know. In addition, the property would have to be completely redone to accommodate a different use, a use that would not, more likely than not, be viable. No one wants to come drink in an industrial park. Number three, relief if granted would not cause a substantial detriment to the public good or impair the purposes and intent of the ordinance or comprehensive plan. Well, I believe that the public good is to lessen, as we indicated in our brief, lessen the blight that having adult entertainment uses in a concentrated area have. And I believe it would be hard-pressed to say that adult entertainment use does not affect residential areas. But that's the very same thing could be said about an airport, the very same thing that could be said about a jail, the very same thing that could be said about any other type of industry or use of a property that is undesirable. So looking at it here, because there's no strip club within the area, there's no condensed area or concentration of strip clubs in the area or adult entertainment use in the area, this would not, I believe we've shown number three. Number four, the variance if granted would be the minimum necessary to alleviate the unnecessary hardship. Well, as I've stated, we met with Mr. Razor. We completely agreed to do whatever we could to be a good neighbor. That is what is important.
Thank you very much for your comments.
Thank you.
If there's anyone else that would like to rebut or comment on the statements that you just made.
I do, just for the purpose of the record, the exhibit referenced, the Action Center report, we filed a request with the Oklahoma City Clerk's Office, and that is the response from the Clerk's Office. So that is an official document generated by the Clerk's Office, submitted to us after request. Additionally, for the purpose of the record, dealing with the 1983 variance expiring on its own terms, I'll submit what we're going to call Exhibit 5. This is the journal entry of judgment in the court case expiring and overruling the granting of the variance. So the variance was not expired by its own terms. It was expired by a district court judge ruling so. Thank you.
I want to make one comment. I think that it needs to be reiterated that each board member can place the weighted amount of evidence submitted in their own manner they see fit as instructed by the municipal counselor. So, in my opinion, I am going to discredit the newspaper article.
All right. We have a motion to deny your variance requests.
We have a motion.
We have a motion to deny. We have a motion and a second. Please register your vote. Sir, you are denied.
Item number 5, case number 13924, request of Shahab Amal for a variance to the nonconforming use regulations located at 1016 Northwest 24th Street.
How you doing?
Good. Would you state your name and address for the record, please?
Shahab Ajmal, 1712 Northwest 12th.
Want to speak to your application?
I purchased a 3-unit property in 2007, and when I tried to refinance it a couple years ago, the appraisal said they can only appraise it for 2 units since it's zoned in R2, and there's nothing's been changed. It's a 3 units, always been like that, and I just requested to have it, you know, for a variance for a 3-unit. It's pretty straightforward. It's not like...
Not quite so straightforward to me.
Oh.
Is there actually someone living in the house at the rear of the property?
Yeah, they're all occupied.
I'm surprised to hear that, frankly, given its condition. The indication of the staff report is that the property was purchased for $70,000, even though it appraised for $42,000. Is that correct?
No, after I purchased it, and I purchased it in 2007, and when I went to get it refinanced in 2012, it appraised for $40,000 because they would only appraise the 2 units. They wouldn't appraise the 3rd unit.
Did you have it appraised when you purchased it?
Yeah, I had it financed. It went through an appraisal, and they appraised it for, I think, over $80,000.
Was your first appraisal based on 3 units?
Yes.
Okay, so then when they came back the second time around, it was noticed that this was it was a zone for 2 units and you had 3, so they discredited the 3rd unit.
Exactly, and
Okay.
I think they just got stricter on the appraisals after the financial crash with the housing market.
I cannot support this application, so I guess I would offer the applicant the opportunity to continue this case until there's a full board here. He's not going to get my vote today or probably
Do you
another
understand
day.
what she's saying?
No.
A full board is 5 members.
Okay.
And it takes 3 members to vote in favor for your variance to be approved.
Okay.
Since there are only 3 of us, it would require unanimous vote by all 3 of us. And what Ms. Powers is telling you is she is not going to support your variance request. And so if you want us to go ahead and conclude, you know, our business together today, you're going to be denied. If you want to ask for a continuous request, and you're more likely to have a full board,
Okay.
your chances of being approved will improve.
Okay, I'll request a continuance.
Is September the 18th acceptable to you?
Can you?
October the 2nd?
October the 2nd would be better. Can I ask why she denied it?
She's just expressing her opposition to your request.
There's no
You would have to have all 3 votes for it to be approved. I will not support this application. I don't think that the property is appropriate for a triplex. I don't think that this is a valid application. The financial hardship is not something that is part of my deliberation, so.
Okay, but I'm sorry, ma'am, but the unit's been existing, the third unit's been there even before I purchased the property.
The third unit looks like it's barely standing to me.
Where did you?
It's boarded up,
No, it's not boarded up, ma'am.
desperately in need of paint and
No.
electrical wiring is.
We're not going to argue.
Okay, I'm sorry, ma'am, but I'm sorry, what pictures have you seen?
I went by the property.
You
and
did?
looked at it.
Oh, okay.
Right now, you're in a position of being denied or
Okay, I was just asking, I didn't know the
stay
rules.
there. I have a request from the applicant to continue to October the 2nd. Stay there.
I'll make the motion.
Second?
Cast your vote. We have a motion and a second. You're approved to October the 2nd. Continue.
thank you.
Item number 6, case number 13927, request of Harbor Homes for a variance to permit a single-family residence encroaching the 25-foot platted front building line located at 8205 Northwest 159th Street.
It's our front building line, our municipal, our code building.
There's just one copy. Okay.
Oh, so is this platted?
Phone down so we can hear you and give us your name and address for the record, please.
Hi, my name's Rebecca Garner. I'm with Harbor Homes at 480 Merchant Drive, Norman, Oklahoma, 73069. We are requesting a variance. It's case number 13927 to the building line, built building line. The home was built at 20 feet and it is zoned for 25 foot. The two homes on both sides are zoned for 20 feet. So it aligns with those homes, but it was zoned to be at 25.
You're not aware of anybody in opposition or anything to your...
Okay.
I'd make a motion to approve.
Second.
I have a motion and a second to approve the application. Cast your votes. Ms. Powers, you are approved.
Thank you very much.
Item number 7, case number 13928, request of Custom Composites for a variance to the front yard setback and required number of parking spaces located at 1019 East Madison Street. I can pass it around, but put on.
If you would, sir, give us your name and address for the record, please.
My name is Hadley Bauer. I have a bad cold. I'm a little hearing impaired to start with. I use hearing aids, but my cold's kind of messed my hearing up today, as well as my speaking voice.
And your address, please.
Normally, Russell Boyd, the president of Custom Composites, would be here today making this presentation, but he had a problem come up at a factory up in Pennsylvania, so he's there and I'm here. The only thing that we would take issue with has to do with the on-site parking spaces, and if you would put up that handout that I gave you.
Yeah, I can't put it up. I can pass it around to the board members so
Okay.
they can look at it.
It's been around the horseshoe.
If you'll notice in that handout, the site is really more than just Lot 2. The site comprises Lots 1, that unplatted area, Lot 2, 3, and part of Lot 4 of Block 2. And on the south side of the street, it comprises Lots 4, 5, 6, 7, 8, 9, 10, and 11. And we have just finished a parking lot for about 60 vehicles in Lots 7, 8, 9, and 10. So we're providing ample parking for that site. Also, I'd like to point out that we were planning to put another manufacturing building in that area that's identified as unplatted, and going over to Lot 2 and Lot 1. If we had to go in there and provide parking spaces explicitly for Lot 2, we would be messing up some plans that we have because of the building going in on that unplatted area will require detention, and the detention pond was going to be in an area between the new building and what we're doing with Building B on Lot 2. Also in that area, we're planning on putting a loading dock for 18-wheelers so that we can get the trucks out of the street and load product on them in a safe manner that doesn't provide congestion. Any questions?
Is there anybody else who's wanting to be heard on this matter?
Anybody from the public that wants to speak on this variance request?
Sir?
Just a moment.
I'll move for approval of the variance.
I'll second.
We have a motion and a second to approve the variance. Cast your vote. You are approved, sir.
Thank you, sir.
Oh. He'd like his plat back.
Item number 8, case number 13929, request of CSW Construction for a variance to permit a single-family residence encroaching the 80-foot platted front building line located at 10540 Twin Fawns.
Good evening. My name is Roger Ward. My company is CSW Construction. Address is 7652 Moore, Oklahoma. I am requesting a variance today on a piece of real estate. We built a house, and unfortunately, an oversight on my part and my foundation sub, it is about 12 and a half feet over the building line. Inside this subdivision, there's 6 other cul-de-sacs, and the building line is from 45 to 105 feet. On all the other ones they all vary. But anyway, we're requesting a variance today.
Is there anybody else who wants to be heard on this matter?
Anybody here to speak in opposition to this application?
These cul-de-sacs just give us so much trouble.
Every week, every other week. I'll make a motion for approval.
Second.
I have a motion and a second. Please cast your votes. You are approved, sir.
Thank you very much.
Item number 9, case number 13930, request of Tyler and Katie Hill for a variance to the minimum lot width and access to an approved street located at 2537 Hill Road.
Good afternoon. My name is Jim Shepard, general contractor, Shepard & Sons Construction out of Mustang, Oklahoma. Address is 1224 East Highline Lane, Mustang, Oklahoma, 73064. The piece of property that's in question today, we're requesting, we're requesting a variance on a 150-foot frontage ordinance for agricultural. The way that this property was divided up originally, and it was before the Oklahoma City annexed the property in to the Oklahoma City, the road dead ends into an 18-acre tract. There's 5.1 acres that's been carved out in this tract, but there's no way to provide for the 150-foot frontage that's required for agricultural. The other point that I would make here is this is predominantly family land. There are 3 brothers, a mother, Tyler and Katie there. It's predominantly family, and they're wanting to do this all together.
Do I understand that Hill Road is actually just this little easement?
Yes,
that
ma'am.
provides access to this property? And it's this, what they call in Ireland, a lane that we see in these photos? This is Hill Road? Yes. Okay. I have two questions about this.
Okay.
That was one of them. The other one is, what does our emergency services department think about things like this? I'm sort of inclined to not be too worked up about it. I think it would be fine, but do they? Okay. Is there anybody else who wants to be heard on this item today?
I want to make one comment, amplify that staff brought up. I don't have a problem with this, but there could be a situation where everybody gets along in a family most of the time, but there could be this situation for litigation. Are they aware that, if it's not them and it's like you sell it 20 years from now to Mr. Smith and Mr. Jones and they get into it,
I believe they are. I've known this family. I'm actually not only involved in the construction portion of this, but I'm friends with this family. And very, very good people, very tight-knit family.
And anybody going forward that would purchase the property, Danny, would be under the understanding that this road is private and that would be disclosed? Okay.
And the easement is filed of record.
Yes,
so.
I just wanted to be sure. I wanted to be clear because you never know. It's not what happens now, it's what happens 20 years from now. So I'll make a motion to approve the variance.
We have a motion and a second. Register your vote. You are approved.
Thank you, Board.
Item number 10, case number 13931, request of InDesign Homes for a variance to permit a single-family residence encroaching the 30-foot platted front building line located at 4713 North Hamilton Drive.
Good afternoon.
Your name and address for the record.
My name is Kevin Durant. I'm with InDesign Homes. Address is 3522 Galatian Way, Yukon, Oklahoma. Case numbers 13931, request and building variance. The home that I built was actually 10 feet over the building area. The house in question actually was burned down. The home burned down in 2008. The guy cleared the lot, and it's been vacant. So I bought the vacant lot and just put the home right back where it used to sit. So I have pictures that I submitted.
Not only do you have a cul-de-sac issue, you've got a grading issue too, from what I understand. Your land goes like this.
Yes. So we brought in at least, I would say, probably 13 dump truck loads from start to finish to try and at least level the sucker out. There's the home. And again, it just lines up right with everyone else. So just requesting a variance.
There being no one in opposition, I'd make a motion for approval.
We have a motion and a second. Register your votes. You are approved.
Thank you so much, Board.
Item number 11, case number 13932, request of Brian Lorenz for a variance to the maximum fence height located at 14201 North Pennsylvania Avenue.
Good afternoon, board members. I'm not Brian Lorenz, but I work with him. My name is Seth Dorman. I'm a permitting and planning specialist for WD Partners. Our address is 7007 Discovery Boulevard, Dublin, Ohio, 43017. And I think that the staff report does a very good job of laying out what we're requesting. Essentially, we're asking for a 12-foot high fence where the code permits 10. This fence would be used to sort of secure the area around where we have our rental equipment at the north, I believe it's the north corner of the building. And again, I guess if the board has any further questions for me.
Make a comment. The proposed fence is small in comparison to the whole big box of the building. This is something, when I do big box development, we do this all the time just to secure an area where there may be something more valuable. You're probably looking at a 86,000 square feet store and you've got a fence area of, not even 1% of it, so I don't have any problem.
Will the fence be site-proof? Will it be opaque? Will you be able to see through it? Are we talking about the same kind of fencing as is on the south side with the, we'll call it cyclone for lack of a better term?
Yeah, it'll be exactly like that. It will have a meshing, like a metal mesh on the inside of it that would prevent climbing or cutting
Okay.
Yeah, but it'll be very similar to what's on this.
And looking at this, I'm quite familiar with this site, as I'm sure Mr. Harris is too. Would 12 feet even bring this up to the same height as the fence that abuts the apartments to the north? And I know there's a significant change of grade between this property and the apartments. Will 12 feet bring you up to that height even? It will?
Yeah, I don't know that anybody's surveyed what's out there, but just looking at pictures, I would estimate the retaining wall to be 3 to 4 feet tall. There's a slight slope, and then you've got probably an 8 to 10 foot board fence that separates the uses.
Okay, I'm fine with it. Anybody else want to be heard?
I'll make a motion for approval.
Second?
I have a motion and a second. Cast your vote. You are approved.
Thank you all very much.
Item number 12, case number 13933, request of Kenneth and Jan Olson for a variance to allow a 1,500 square foot accessory building exceeding the maximum 1,250 square foot requirement and encroaching the 25-foot side building line located at 9924 Don D. Road.
You would give us your name and address for the record, please?
The address where I'm presently living?
Pardon me?
The address where I'm presently living?
Yes.
Okay. My name is Kenneth Olson. We live at 704 Heisel Drive in Del City, Oklahoma. Obviously, some of the three things that has been mentioned on this is I'm wanting to put my accessory building 5 foot from my property line. I'm wanting to do that because if you'll notice, my house up there is approximately 40 foot from my property line. I'm wanting to put it behind the house. I want to put it beside the house, but yet still be behind the house. So in order for me to do that, it's 30 foot wide. I have to be 5 foot, or even I could be 10 foot, I guess you could say, from the property line. That's my biggest concern by putting it on that side of the house, because there's less slopage on that side of the house as compared to the east side of the house. I have a lot of trees, and my slopage is a lot greater than on the west side. My other thing that I'm requesting is a 312 pitch on this building, because a 412 pitch costs about $800 more because it's considered a special build. So that's why I'm requesting that, and I'm requesting a 30 by 50 building just because I had to file a variance. So, does anybody have any questions?
Danny, the pitch isn't an issue, is it? That we need to approve? It is? Okay.
I did have a couple of questions. How far are you from your neighbors?
How far am I from my neighbors?
Yeah,
on the west side? His house is probably at least, I want to say, 60, 70 foot.
Have you talked to them about this?
Yeah, we're good friends. And he was wanting to build a building too. He just didn't want to do it at the same time that I'm doing it. And he doesn't have to face the same problem on the west side of his property, because that's where he was wanting to put his. And his is going to fall within that 25-foot thing.
And are you going to be able to keep the trees?
Pardon me?
Are you going to be able to keep the trees that are there?
Yes, because I've only got 2 trees on that east side. Excuse me, yeah, on the west side, I've only got 2 trees, and yes, I'm trying to keep all the trees I can keep.
Anybody else?
I'll move for approval.
I have a motion and a second. Cast your vote. You are approved, sir.
Thank you.
Item number 13, case number 13934, request of Camping World for a variance to the maximum driveway width located at 13111 Broadway Extension.
Good afternoon. My name is George Marquez, and I'm with Craft and Toll, 214 East Main, Oklahoma City, Oklahoma. I'm here on behalf of Camping World, who is located at 13111 Broadway Extension in Oklahoma City. We're asking for a variance to widen the existing drive into the facility. Due to the high volume of traffic and size of vehicles entering and exiting the current facility and their large turning radiuses, the facility requires a larger driveway to accommodate concurrent entering and exiting of RVs to and from the site.
Is it possible for us to condition the variance on the use of the property? I mean, I totally get it's really kind of a safety issue with respect to these very large vehicles.
But it can always be a place where very large vehicles are used.
Yeah, well, and as long as it is a place where very large vehicles are,
You need it.
yeah, then I get that. But if it were to turn itself into a car dealership or something like that, I just as soon see that the ordinance complied with.
I'd agree with that. I'd make a motion subject to the use.
Second.
Motion and a second. Cast your vote.
Janice?
You are approved, sir.
Thank you, appreciate it.
Item number 14, case number 13935, request of Oklahoma City Public Schools for a variance to allow the continued use of exposed exterior metal siding on 6 temporary classroom buildings, to add 6 new temporary classroom buildings with exposed exterior metal siding, and the required number of parking spaces located at 6708 South Santa Fe Avenue.
Hi, my name is Gary Jewell. I'm project coordinator, capital improvements, Oklahoma City Public Schools. I guess as well as you guys know, for the last about 13 years, we've been in the process of remodeling and adding on and building schools through Oklahoma City, through the Maps for Kids, and then also the 07 bond. During that time, we have added a lot of square footage onto the schools, remodeled a lot, and our plan was to do away with all of the annexes. But over the time, our little crystal ball didn't quite tell us quite right of how much growth we were going to have, especially on the southwest side of Oklahoma City. So even on the 07 bond issue, we have added 50-plus classrooms into our schools, and we're finishing those up right now to alleviate some of the overcrowding that we have. But again, not knowing how much growth we were going to have, we have a situation at Webster Middle School that we need to keep some annexes there. We did take away 11 from Jackson, and 5 of them we disposed of. 6 we need to move over to Webster to allow for overcrowding. We're trying to make as much of them go away as we can. We had anticipated this last year to maybe go out for a bond issue. Of course, when we had our superintendent retire last year, nobody wants to go out for a bond issue without somebody permanently at the helm. So we're waiting now. We have a new superintendent, Mr. New, which has a lot of good ideas for our school. And so our plan is to, in the near future, hopefully go out for a bond issue. That way we can build some additional schools on the southwest side and to, again, take away the rest of these annexes that we have.
I have no problem with this. We get these from time to time. This is part of a comprehensive plan for the Oklahoma City Public Schools, and you're asking for another 3 years, and as this ebbs and flows, I know that the construction process over the entire school district is going to ebb and flow as well, so I have no objection.
The staff report indicates a 5-year horizon.
5-year, I'm sorry, it was 3
Yeah,
years.
because in the real world, time you go through planning, pass one, everything else, we would anticipate it would definitely be closer to the 5 years, so.
Is 5 years adequate?
We're going to ask that for right now. I mean, we would probably like to ask for whatever, because we don't know yet. We're at the mercy of you guys, of what you guys would allow us to do. If you don't have to put a timeline on us, we do. I will bring it up now that we do have 2 additional schools down on the south side. Both of them are middle schools, as Roosevelt and Jefferson, that have 12 classrooms that are annexes at each location. That our variances have expired, and we're getting ready to submit again for variances on those also to extend those until, again, the same thing. Anything else that we're doing now, we're trying to make sure we do them with not metal-cladded buildings, so we don't have to worry about these variances, anything that's on a temporary basis. So, again, we don't want these here. We just have the situation right now on a time constraint and money.
How much latitude does the board have in terms of, I don't want to be dragging them back every few years with a variance request, but at the same time, we don't want to create a scenario where we never revisit the issue.
Gotcha.
I'm comfortable, I think, with 5.
Can we do 5? I thought by statute we were limited to 3. Is that just on the hardship? That's just on hardship? Okay.
I mean, I would prefer 3, frankly, but I think I could live with 5, given the constraints of financing and,
I think given the fact this is a unique deal, we're dealing with our financing, it's the Oklahoma City Public Schools, it's not another matter. I'd make the motion for 5 years.
Second.
We have a motion and a second. Cast your votes. You're approved for 5 years, sir. There's
And I
no other-
appreciate you guys getting me through. I was a little nervous after that first case.
Well, I had my times incorrect.
Well, and on that first case, I wish we would have been able to be notified. You know, it's only within a certain amount of feet from a situation like that there, and I didn't know if I had the opportunity to be able to speak on that when y'all asked for additional speakers, but I...
Anybody interested can...
Any interested party can speak at any forum, right?
But I felt you guys were going the right direction.
Well, thank you.
Thank you, guys.
If there's no other business, I would entertain a motion to adjourn.
So moved.
Cast your votes. We are adjourned.
Good job, Acting Chairman.